2, 1, live.
Good afternoon. Recognizing a quorum of commissioners, I call the December 4th, 2024 meeting of the Cannabis Control Commission order. This meeting is being held remotely pursuant to Chapter 22 of the Acts of 2022 and is being recorded. Commissioners Camargo, Concepcion, Roy, and myself are participating in today's meeting. All votes taken today will be by roll call. We have a pretty full agenda today that I will generally summarize. We will start with the commission discussion and vote section. We have an open meeting law complaint and public records request. We have a governance charter mediation sessions records update, and we have a governance charter update. After those agenda items, we will be transitioning into executive session. Let's jump right into the first item, which is the open meeting law complaint and public records requests. And I'll hand it over to our General Counsel, Kajal Chattopadhyay, and Associate General Counsel Michael Bergquist, I believe, is also supporting the discussion on this item and the next item. So with that, I'll turn it over to our General Counsel.
Good afternoon, everyone. Happy to see you all. Hope you all had a very nice holiday. I do want to acknowledge that Associate General Counsel Mike Bergquist is joining me here in the virtual space, as well as Michael Baker, who I'm happy to report has formerly been called the Acting Deputy General Counsel, but we can now drop the acting, and he is now officially the Deputy General Counsel. So happy to make that announcement here today.
Congratulations.
I wanted to start here sort of broadly and then get into the specific complaint at issue. As you're aware, for individuals seeking records from government agencies, whether they're state or local, there's a public records process. And the public records process is supported by statute. And there's a process laid out there whereby a requester submits a request to the agency. The agency has a certain number of days to respond, and the process is outlined in the statute. If the requester is not satisfied with the response or believes they are entitled to additional records, then they have the option of appealing that decision to the supervisor of records, who sits within the Secretary of the Commonwealth's office, and that person then the supervisor then will make rulings and generally oversee the process in terms of getting records and making rulings as to what is a public record, what is a public record, and what is not. So that's one process that is separate and distinct from the open meeting law. The open meeting law, it governs public meetings of bodies like ours, and is governing this meeting here. That is also set forth by statute. Obviously, there are certain parameters that are set forth for the conduct of such meetings, and for individuals that have an issue with anything pertaining to an open meeting, there is a separate procedure by which to deal with those complaints. And generally speaking, that is handled by the Division of Open Government at the Attorney General's office, who oversees compliance with the open meeting law. So we're talking about two entirely distinct and separate processes that don't coincide in the normal course. Now I want to zoom into the case here at hand. So this all emanates from a public records request made by the former chair, Shannon O'Brien, for certain documents emails and other documents, as well as minutes and a video recording of the April 24th, 2023 executive session, which involved discussion regarding the governance charter that the commission has been taking up for some time, delineating roles of certain officials within the commission, executive director, the chair, and others. There were a series of meetings to discuss that charter. Former Chair O'Brien was requesting that particular video, that request came in on October 16th. We responded to her request on October 30th, provided a preliminary response with some documents, and also indicated that we would need a little additional time to conduct our search for other documents and to complete review of the video and getting it ready for release. Thereafter, on November 15th, we did provide the video, but I should back up and mention that in our initial response, we also provided her with access to the minutes of the meeting, which were publicly available. They had been voted on and approved for release by the commission back in September and have been available to the public since that time. So in our initial October 30th response, we had included the minutes to Chair O'Brien for her review and indicated that we needed a little extra time to get the video ready for release. On November 15th, we followed up with some additional documents, as well as a redacted version of the executive session meeting that she requested, which again was April 24th, 2023. Thereafter, rather than going through the normal process of appealing to the supervisor of records, Ms. O'Brien filed an open meeting law complaint alleging certain violations of the open meeting law, and specifically that her opinion that none of the sessions that were conducted in executive session to discuss the governance charter should have been conducted in executive session. That was filed in her complaint to us. We then, and I should point out, it was Assistant General Counsel Mike Berquist, who was our record access officer and has been working on this case. He then consulted with the Division of Open Government at the Attorney General's office as to the proper procedure to respond to this complaint. In the complaint, Ms. O'Brien does acknowledge that the complaint is not timely because the law has set forth a 30-day deadline from the date of the alleged violation in which to file a complaint. Pursuant to the advice from the Attorney General's office, we are required to meet to discuss the complaint, which we are doing here today in public meeting, and then to take appropriate action. And so that's kind of the backdrop which gets us here for our action today. As I mentioned to you, the complaint is not timely. The statute does set forth a 30-day deadline in which to file alleged violations or complaints for alleged violations. We are well beyond that time. We are, I think, 19 months after the date of the alleged violation, so clearly outside the time frame envisioned by the statute. And I'm going to seek a motion from you all after we're done here with our discussion to direct the legal division to reply to the complaint in accordance with the open meeting law. I did want to take a second to just talk about, in the spirit of transparency and as well as general context, talk about the full universe of the materials relating to the governance charter discussions and what the legal division has produced thus far and what remains. So there were 16 sessions in total that were conducted in executive session to discuss the governance charter. At this point, we have reviewed and released sessions 1 through 6. Those have been up and posted on our YouTube page for several months now. We are in the process of finalizing our review of videos 7, 8, and 9, which I expect will be released very shortly. And we have, pursuant to the request of former Chair O'Brien, released the video of meeting number 15, which is the April 24th, 2023 meeting, so that leaves 6 more sessions for us to go through and to make available. I would like to note that all 16 sessions in total comprise more than 80 hours of video recording, which the legal team has spent conservatively at this point over 250 hours going through for matters that need to be redacted from the video, whether it's legal discussion, privilege matters, matters that involve personnel matters, those sorts of things. The legal team has spent considerable time going through that. Already, like I'm saying, over 250 hours, and we will continue to do that process. We are working diligently to get the remaining videos up and published, and it is one of my priorities as the new general counsel to get those completed in a forthright fashion. So we are working speedily to do that. So I just wanted to provide that for context. In addition to that, as I mentioned before, the minutes of all the sessions have previously been released. They were voted on and released by the commission in September. So those have been available to the public since that time. And as well, a copy of the most recent chart, the governance charter, the draft charter, has also been posted and available to the public since September. So again, in the interest of transparency and just letting people know the status of all of the materials related to the executive sessions, wanted to throw that out there. I do want to just, before turning it over for discussion, mention that the remedy for an open meeting law complaint would be to release the minutes, which, as I mentioned to you just now, we have already done. So while Ms. O'Brien's complaint is untimely, the remedy to her complaint has also been provided by the commission. So I would include that in our response. And as I mentioned at the top, we'll be looking for a motion from the commissioners to direct legal to respond to the complaint in conformity with the open meeting law. And with that, I'm happy to turn it over for discussion.
Any of my colleagues? I see you, Commissioner Roy. Go ahead.
Thank you, Chair Stebbins. Thank you, General Counsel. Are the video recordings considered an official record of the session?
Well, they were recorded, and as a result, I would have to say yes, they are.
Okay, so official minutes must contain detailed information, names of members, summaries of matters discussed, a list of documents used, and all decisions made and the actions taken, including a record of all votes. Documents and other exhibits need to be kept as part of the official record of the session. Now, when we say timely manner, the statute also applies to the release of the minutes in the official record in a timely manner. So minutes of all open and executive sessions shall be approved in a timely manner. A timely manner will be generally considered to be within the next 3 public body meetings or within 30 days, whichever is later. unless the public body can show good cause for further delay. So I guess my question is, we're applying a standard of timely manner to Ms. O'Brien, but we have not adhered to the timely manner ourselves because we still have tranches of videos that fall well past the 3 public meetings or the 30 days. So I'm just saying we have extended past the time, what is considered timely manner ourselves.
If I might respond to that, Commissioner Roy, the portion that you just read, that involves public meetings, not executive sessions. We are talking about executive sessions, so there are different rules that apply to executive session.
May I, Chair?
Yeah, of course.
Okay, yes. So the purpose of the executive session expired on September 12th of 2024. So therefore, the clock started ticking when the purpose expired when we voted. So wouldn't that be applicable? The clock would start at that point.
Again, we'd have to look at when the purpose ended.
September.
Yeah, and to my understanding, the governance trial being discussed, but as I mentioned to you, we are as a team working diligently to get these videos out as quickly as we can. I mentioned to you that we have put in over 250 hours of staff time to date. This is a very time-intensive proceeding to go through all these videos, and we have committed a large portion of our legal resources to doing this. And as I commented myself, I have prioritized this to get done as speedily as we can.
Go ahead, Commissioner.
So you said the violation occurred in April of 2023, not the violation occurring of withholding elements from the video. In other words, the video didn't get published until November. So how could one know there was a violation of open meeting law if the public wasn't able to see it? So open meeting law complaints must be filed with the public body alleged to have committed a violation when 30 days of the date of the violation occurred, or if the complainant could not have known about the violation within 30 days of the date that the violation should reasonably have been discovered. So was the violation occurred in April of 2023, or is the matter in question the redaction, and is there an exemption for that redaction?
Well, if I may.
Of course.
Just to respond. So in this situation, former Chair O'Brien was actually presiding over the meeting that she has sought the recording for. So it would have been apparent to her on the day of the hearing of the session that if she thought there was a violation, that would have been apparent from the date of the hearing, the date of the executive session. So the clock would have started ticking at that time. And if she felt like there was a violation of the executive session or the open meeting law, she could have filed a complaint because it would have been, again, known to her at that time.
Commissioner Roy, do you have anything else?
I guess I'm interpreting it as the violation of open meeting law to be the commission withholding elements of the tape, and not when it occurred in April of 2023. That's how I was interpreting it.
And, reading through the complaint, and GMGC, correct me if I'm wrong, I believe there's an acknowledgement by the former chair that she realizes her filing of the open meeting law complaint might be outside the window of the 30-day kind of time frame.
That is correct, Acting Chair.
Okay. Commissioner Camargo, Commissioner Concepcion, do you have any questions?
have any questions. I think that Kanjo in the beginning explained the next steps. That's the only thing I would have a question about is just next steps.
Kajal, did you hear that?
I did, yes.
Okay.
Thank you, if I may. The next steps, we are seeking a vote from the commissioners to direct legal to respond to the complaint in accordance with open meeting law. The response would include the two things that I mentioned, that it is, one, untimely, and two, that the remedy for the alleged violation would have been release of the minutes, which have already been released.
Commissioner Concepcion, do you have any questions?
I do not. Thank you.
Okay, thank you, Commissioner. GC, just a more process questions than anything else. You walk through the process with somebody seeking a public records request, and the opportunity that if someone seeking a request has a difference of opinion over how we publicly make those records available, they can appeal that to the supervisor of records, right? I believe,
Correct.
just for
That's right.
clarification, that person sits within the Secretary of State's office.
That is correct, yes.
Okay. And obviously the appeal process is depending on the decision of the supervisor of records decision, does a complainant have the opportunity to appeal that decision as well, or is it kind of the buck stops with the supervisor of public records? No,
there is a further process after that. The requester then can take the matter to court if they so choose.
Okay. All right. Commissioner Roy.
General Counsel, can you share, I think you're looking for a motion to approve you could you repeat what you're looking for, so I understand?
Or if
Sure.
you want to drop it in the chat, General Counsel.
Yep, why don't I read it? So what I'm looking for is a motion to direct legal to respond to the complaint in compliance with the open meeting law. And I'm happy to write that in the chat as well.
Is there any need in that motion to address the public records request, or do we feel we have completed that matter on our end?
If I may.
Go ahead.
At this point in time, we have responded to the public records request fully, and there is nothing for us to do in addition at this time.
Other than, obviously, the team is working to get out the remaining videos of the executive sessions, as you kind of went through the inventory of what remains to go out the door.
If I may, I'll point out that,
of course,
the former chair's records request only sought the video recording of that one particular session. So that is the April 24th, 23 session. We are, pursuant to Commissioner Roy's point earlier, finishing up the review of the other recordings, pursuant to the obligation to get those out, as expeditiously as we can, since the purpose of the executive session has ended.
Okay, thank you for that. Commissioner Roy.
And General, thank you, Chair. And General Counsel, what will be the response to Ms. O'Brien based on approval of this motion?
If I may.
Of course.
again, restating, the response will be that her request is untimely, it's past the 30 days, and that regardless of the timeliness of the complaint, that the remedy for the alleged violation is to make the meeting minutes available, which we have already done. So essentially, we have already remedied any alleged violation.
Commissioner Roy, go ahead.
Thank you, Chair. In general counsel, but minutes and video recordings are two different animals, if you will. Minutes are more high level, where the video is verbatim. So they're not exactly apples to apples, correct?
If I may.
Yes.
Yes, that is a fair statement. I should add that the team, as it has reviewed all of the videos, has erred on the side of transparency and of releasing everything that is legally permissible. We have only redacted materials that we believe would not be appropriate to release under the applicable legal standards, involving records that may constitute an invasion of privacy or identified individuals, and there are legal tests that we apply to make sure that we are complying with the law and balancing that with the public's need to know, which is also part of the legal standard.
GC, do you want to put your motion into the chat and we can have some discussion around that?
I'll do that right now.
Of course. Okay, the motion, drafted motion is in the chat. I'll read it out loud. The draft motion is to direct legal to respond to the complaint filed by former Chair O'Brien in compliance with the open meeting law. Any questions about the motion or any questions for GC? Commissioner Camargo, go ahead.
I know this is not a big deal, but should we add her first name as well, like Chair Shannon O'Brien, to the motion?
If I may, I have no problem with that.
Okay. Commissioner Concepcion or Commissioner Roy, any questions on the motion? I'm not seeking a motion yet, but certainly giving commissioners a chance to read it and respond to it.
I have no questions.
Okay. Commissioner Roy, go ahead.
I have no further questions. I just have a small statement when I make my vote.
Okay.
Thank you.
All right. If there are no further comments or questions, I would seek a motion that will direct legal staff to respond to the complaint filed by former Chair Shannon O'Brien in compliance with the open meeting law. Do I have such a motion, Commissioner Concepcion?
So moved.
Commissioner Roy, do you choose to second that? I'm trying to save Commissioner Camargo's voice here. Commissioner Camargo, will you second? I think that was the second. Can you give me a thumbs up? Okay.
Yes, second.
Thank-
Second.
Okay. Thank you, Commissioner Camargo. Motion been made and seconded. Any further comments or questions? Seeing none, I will do a roll call vote. Sorry, Commissioner Camargo, but I need to ask you for your vote.
It's okay. Aye.
Okay, I have an aye. Commissioner Concepcion,
Aye.
Commissioner Roy,
I am a no, and I, with record, would like to state, obviously, we are a public agency and, the public's need to know is pertinent here and it must be considered. And in light of that, I'm not comfortable with that selected redaction. So on principle, I will vote no. Thank you.
okay. And Commissioner Stebbins, I vote aye. So 3 in favor, 1 opposed. The motion carries. The next item B, which is the governance charter mediation sessions records update. I think Conjali, you gave us, or General Counsel, you gave us a little bit of an insight into that in terms of what has been produced, what has been released, and what is still in process. Anything you want to add to that? But I think you covered that in the early part of your presentation.
Yes, if I may.
Go ahead.
Yeah, I think I may have bled into this in my earlier comments. So nothing more to add. I did go through the universe of all the materials and all the efforts that the legal division has undertaken to date to get this work done. But I'm happy to answer any further questions. There is in the meeting packet a listing of each of the 16 sessions, the minutes that have been released, the videos that have been released to date, and the ones that remain, as well as the government's charter draft. So I'll leave it at that.
Okay. I don't think unless there are any other questions, we'll move on to just to offer a quick update on the governance charter work. I know we last, as a body, went through the governance charter back in September. As we were going through the document, I know my colleagues and I put a lot of pins in place. That seems to be just a new terminology that pick up in all of our work at the CCC. We put some pins in some of the governance charter measures that we have been going back to and reviewing. I want to thank our Chief of Staff, Andrew Carter. I asked him to kind of just circle back with all commissioners, see how their work was going to address those pins. I know I have had a session both with Andrew and with our general counsel to review a couple of the pins I was assigned. I know in terms of an update, the Chief of Staff and the GC are trying to line up meetings with commissioners 2 by 2 to kind of walk through what some of those final changes or edits might be. And looking to coordinate commissioner calendars with respect to doing that final review. I also understand that the Chief of Staff has shared a current draft of the charter with the chiefs. Many of those folks were not involved, obviously, in the process, but I think it's giving them an opportunity to see the document and gain some understanding as to the purpose of the document and what some of the provisions mean. So the work is ongoing. Greatly, as I said, greatly appreciate the collaboration and efforts of my colleagues to go back to some of the points that we still had questions about and try to resolve those. And we'll continue this work until we can hopefully bring a final draft forward here in not too distant future and get that work wrapped up. Okay. There's no new business anticipated at the time of posting. We have some future meeting dates coming up, and we can move to that slide. Obviously, tomorrow in Worcester, both in person or remote, we have a meeting scheduled to present the social consumption regulatory framework. That'll be, again, tomorrow at 10 a.m. We have our monthly business meeting scheduled for next Thursday, December 12th. That'll be a lengthy meeting. And then we have one more meeting currently scheduled, which is December 17th. That will be an opportunity for commissioners to work alongside staff and go through the red line version of the social consumption regulations. I would also just flag for my colleagues that with the second meeting in December, I did reach out to our Division of Licensing just to see if they had any folks who, because of our timelines, might have missed a window to be on the December 12th business agenda, and invite them to provide us the opportunity to review any provisionals, finals, renewals, or changes of ownership at our December 17th meeting before we kick off the red line regulatory review. And I understand that they might have a couple of items for us to consider on the 17th, and those are folks who might have just missed our deadline cutoff to be included on the December 12th meeting agenda. So those are the dates upcoming. Any questions or comments at this point? Okay, seeing none. Next, I will entertain a motion pursuant to Mass General Law, Chapter 30A, Section 21A2, to conduct strategy sessions in preparation for negotiations with non-union personnel, or to conduct collective bargaining sessions or contract negotiations with non-union personnel. In General Law, Chapter 30A, Section 21A3, to discuss strategy with respect to collective bargaining or litigation, because the open meeting may have a detrimental effect on the bargaining or litigating position of the public body. Is there such a motion, Commissioner Concepcion?
So moved.
Is there a second, Commissioner Roy?
Second.
Okay, motion made and seconded. Let the record show the motion was made by Commissioner Concepcion, seconded by Commissioner Roy. Are there any questions or comments? Seeing none, hearing none on the motion that has been seconded, I will take a roll call vote. I would like to ask that before you vote, you verbally affirm that you are alone and nobody can hear the deliberations. Commissioner Camargo, I hate to ask you to do this, but can I have your vote, and can you confirm you're alone?
Yes, and I can confirm that I'm alone.
Okay, Commissioner Concepcion.
I can confirm that I am alone and no one can hear my deliberations.
Okay, Commissioner Roy.
I can confirm that I'm alone and no one can hear my deliberations. Aye.
Okay, and I can also confirm that I am alone and no one can hear these deliberations, and I vote aye. Let the record show the motion was approved unanimously. We will now transition into executive session. For the record, the individuals participating in this session will be the four commissioners, our acting executive director and chief people officer, Deborah Hilton Creek, our general counsel, Kajal Chattopadhyay, acting deputy general counsel, well, he's not acting anymore, deputy general counsel, Michael Baker, Jackie Kugel from our outside law firm, and paralegal Ivania Corrales-Solis. And as a reminder, the commission will not reconvene in open session and will adjourn the meeting from closed session. With that, thank you, everyone. I will see you in executive session. Appreciate it.